Good evening. Thank you for being here. I am Barb Bultice with Crossroads School. Crossroads is my passion, and I know a lot of you have been involved or know about it, but that's not why we're here tonight. And this isn't anything about promoting Crossroads. This is about providing information and giving some resources that are valuable for all of us. So I just wanted to host this as an opportunity to share some really good information. So I've got 3 guests with us. I'm going to let each of them introduce themselves a little more when they come up, but Julie Caravas is a estate planning attorney, so she's going to have some good information for us. Tony Pickett is the director of a of a family foundation. Is that a good way to say it? Okay. So she's got the perspective of working for a family foundation and knowing some of that perspective. And Reggie Golden is a community member who has done a lot with estate planning for his own family. And so he's going to speak from that perspective of how have I chosen to go about this? And then one other person, Sally Glass, wanted to be here, but is actually in New Zealand. I'm a little jealous. And so she actually wrote a letter sharing her perspective, another person coming from a donor perspective, an estate planner perspective, to say what she has chosen to do in her family, just to give another perspective. So we'll hear from each one, and then we'll have some time for questions and dig in a little deeper into the things that you guys are interested in. Okay? All right, I'm going to let Julie start us off.
Good evening. My name is Julie Caravas, and I am an attorney. I have an office in Boulder. The firm is Caravas and Crayons, and I did leave some cards out on the table. My practice involves primarily estate planning, but also some business work with closely held family businesses. I do a lot of work with egg producers, farmers, ranchers, but also what I would call more urban family businesses as well. Ideally, it's transactional, but occasionally when family members or business partners don't get along, we end up in court, so I can do that as well. I am licensed in Colorado as well as Nebraska. What I'm focusing on tonight is just estate planning, and as the sign said when you came in, Estate Planning 101, which means there could be a whole lot more classes or talks on this that would go into more detail. So as I had said when Barb and I were talking about this, that certainly we can summarize and focus on a few things, and I'm going to do my best to do that in about 10 minutes, but I will tell you that any one of these topics we could spend hours on. So what I want to touch on, and you can feel free to ask questions later, or certainly after this evening, if you have any individual questions, please feel free to reach out to me. I do think what is important about estate planning is that everyone realizes it's about choice. It's not about how big your bank account is, how large your family is. It's what do you want done with your assets when you pass, or perhaps how do you even want help managing those while you're still living, and who do you want to be the person or the people to assist you with these kind of roles, which we would call fiduciary. There's a lot of strange words that we use with estate planning, but someone that's going to act on your behalf. And if you don't do this kind of planning, I often hear people say, well, if I don't do planning, the state's going to take my money. The state isn't going to take your money, but the state, regardless what state you live in, effectively would have an estate plan for you. Meaning if you pass and you don't have a will, then believe it or not, there is state law that says how those assets will be shared. And if that makes you cringe to think, my cousin that I don't care for that much could end up inheriting, the answer would be yes. And so you probably should do some planning. What is a basic estate plan? At a minimum, I think there are at least 2 documents that are very important while you're living. And they're both referred to as power of attorney documents. And there's one that focuses on financial needs and another one with health or medical. And to put it in simple terms, because really all of this can be discussed very simply. I mean, I think that's sometimes why people don't want to do estate planning, or they say, oh, it's so complicated, or I feel silly, I'm not sure what questions to ask. I often tell clients, You should not know about these things unless you do what I do, or perhaps like Reggie, if he's been familiar with just doing his own plan, then you should. But if you know these things, whether you're planning or you're administering an estate, you probably need to get a hobby, because there's a lot of detail that you should not know, and you should rely on people that can assist you with it. So a power of attorney, you would be the principal of it. You're the one saying that this is my document, and I need to have someone who can step in and act as my agent if I'm not able to do banking, to sell my house, to talk with the insurance agent. I need someone to be able to help me do that, but I don't want them to have ownership of my assets, okay? That's what a financial power of attorney document provides. So you as the principal, name someone as your agent. Once the principal passes away, the agent has no one to act as agent for, so that power stops upon passing. And that's important to remember, because I will occasionally get calls from a very irate adult child after the parent has passed and says, the bank won't let me have access, I'm power of attorney. Well, yeah, your parent passed, so you no longer have that authority. Similarly, the same thing for health care. If you are not able to make decisions regarding health care or obtain your own medical records, you should have someone that acts as your agent to have that authority, okay? You can have, this would be a discussion when you start getting into the details. Do you have just one person? Do you have multiple people? It's not a one-size-fits-all, so that's something that you can discuss as well. What's important to remember about these documents is if you do not have power of attorney documents and you suddenly or gradually lack the capacity to make these decisions, and you can't do your banking, you can't talk to the doctor about your own decisions, no one else, once you reach the age of majority, so in Colorado, once you're 18, if you can't do these things, and you don't have a power of attorney, that's when you hear of people having to go to court and having a guardian or a conservator appointed for you. And just because you have a spouse, your spouse does not have any legal authority over you, okay? So casually, if the doctor trusts that you want your spouse to speak for you, that might work. But legally, there isn't anyone. So, and I do a fair amount of representation of people getting guardianships and conservatorships, and there is a time and place. But as far as all of you sitting here, that you're able to communicate, make that decision, there is absolutely no reason you should ever be faced with having to have a guardianship or conservatorship. They get very costly, and it's very intrusive. The court knows everything, okay? Having said that, there is a time and place, and I have the pleasure of working with families that have, oftentimes as I'll refer to them, as special need kiddos, that perhaps a child was born with some special needs, and they, from the very beginning, can't make those kind of decisions, even when they become an adult. And so it is very necessary that guardianships be that a guardian be appointed for a child like that, and that's one of those times. Then we get to what kind of document do I need to address how my assets will be shared when I pass? This, seriously, we could spend 2 full days talking about. So just very snippet of this. The most common document people think of is a will. A will addresses how you wish for your probate assets to be shared. And I'll touch on probate here in a moment. But a will typically provides for 3 things. Who's going to be the personal representative? The older term is executor, it means the exact same thing. Who's going to administer my estate? Second thing, if you have minor children or anyone that you are guardian of, who do you want to be the guardian? And then the third thing, how are my assets, my probate assets, shared upon my passing? The will only comes into play when you pass, okay? So effectively, we talked about power of attorney, who can help you with financial matters during your life. This wouldn't be a perfect answer for, say, a law school exam, but practically, after you pass, the personal representative is kind of like the power of attorney was during your life, okay? I still am going to come back to probate here in a second. But the other document that you may be interested in, and you've probably heard of, is a trust. There can be a variety of types of trusts. Most generally, when we talk about estate planning, what we're talking about is a revocable trust, or depending how you pronounce things, some people say revocable trust, okay? They're also referred to as living trusts, grantor trusts, settlor trusts. It all means the same thing. And what that is the trust can be used during your lifetime as well as after you pass. The same provisions you might put in your will, you could have in your trust, okay? Why would we use that kind of a trust? It can help avoid probate. So I'll go back to the probate term. We have probate assets and non-probate assets. Probate assets are those that if you look at the face of them, they don't tell us what we're supposed to do with them when you pass. An example, if I looked at any one of your car titles, there's a very good chance it may just have one person's name on it. Don't know what we're supposed to do with it. Your will would control, which means we have to go through the court, get a personal representative appointed, and that's how your assets pass. Non-probate assets, if we look at the face of it, it tells us what we're supposed to do when you pass. A non-probate asset is not controlled by your will. Non-probate assets, anything that you jointly own with someone. Oftentimes spouses will jointly own their homes, okay? After the first one passes, the survivor automatically owns the home. But if you do nothing more, when the second one passes, suddenly it's just in one person's name. It's probate, and then that person's will controls. Other types of non-probate, anything with a designated beneficiary, whether like life insurance or on a bank account, a pay on death, or a brokerage account, a transfer on death, it tells us where those assets are supposed to go. That's not controlled by your will. And anything held in a trust, owned by a trust at your passing, is also non-probate. So it's very easy to get the assets to whom they're supposed to go after you pass without involving the court. You can also, if you just used a will because you don't think you need a trust during your lifetime, it is possible to build into the will a trust that we call a testamentary trust, because it's a last will and testament. So it's a trust that's created in your will. Why do you do that? Oftentimes, parents with young children may say, well, I just need a will, but if we pass when our kids are young, we don't want them, and they can't, get the assets outright. So we can build in trust provisions in the will that will only come into being after the person passes and there would be young children. Back to the comment about special kiddos, if we need to have trusts that perhaps protect public benefit based on financial need or other special provisions, you can do that. And this is where I probably need to wrap up here. There's a whole lot more we can talk about, but I just wanted to touch on that. You can also use irrevocable trusts. That's a whole nother topic, something that you can't change. I guess one of the points I would emphasize now, though, is when you use trusts, or even if you're using a will, when I think we're going to hear from Tony and Reggie that there are ways that if you have special gifts that you want to make over a period of time, whether it's for charitable or for family or some other special reason, there's ways you can do that. And a trust, I think of a trust as a bucket, and so you're holding on to that bucket, and while it's revocable, you can pour things in, take things out. But when you pass and it becomes irrevocable, you're not holding on to that bucket. And so you can't change it. And if you've said, for example, you want certain charitable organization to benefit, it will, and what you have put in place will be respected. Okay, so that's one thing to think about with a trust as opposed to just a will and everything goes outright. I will be happy to answer questions after we hear from the rest of the speakers, but I will stop now. Okay? Thank you.
Good evening. My name is Toni Pickett. I am the Executive Director with the Brawley Family Foundation. We are a private family foundation here in the Longmont area. Our mission is to help with education from cradle to career. And like I said, we're in Longmont, so we support the St. Vrain Valley service area throughout here in Colorado. And then we also have some giving that we do in Montana, which was another location that our founder lived. It's a very small community there. And so we are what in parts of the philanthropy world, we call ourselves place-based. So we just work here and then in Montana and try to keep our giving in those areas that serve the communities that our founder had lived in and also where his heart was. So I just wanted to talk a little bit about a private family foundation. Let me just get my notes organized here on the podium. So foundations are a possible avenue when you are planning for your estate. Our founder started the foundation as a way to shelter the assets from taxes back in 2006. However, the estate tax laws have changed quite a bit since then. And so you need to just be sure that you understand. At that time, it seemed very prudent to put together a foundation the way that he wanted to do it, but things have changed so much since that time that it was established. You just have to be aware that the laws really do move quite a bit depending on what the federal government decides to do. So we were established in 2006. In 2014-15, we had an event that created cash for the foundation, so we had to distribute 5% of the fund total, and that's part of what the rules are. So let's say your foundation is $10 million. You're going to have to give away $500,000 each year to meet the IRS regulations. And so when you think about giving away $500,000 each year, that takes some effort and some planning and some knowledge to be sure that you protect yourselves and you don't get in a lot of trouble. So that's what I'm going to talk about, is how it is a little bit complicated. And I became involved in 2014-15 as we were trying to figure out the 5% giving and where I could help him figure out within the community to put those funds. So as you're putting together a family foundation, you're going to want to establish goals, a vision for the future. You're going to want the donor intent, and also think about family legacy. When you establish a family foundation, you want to think about if you're going to have this go on forever in perpetuity, or if you're going to have just a spin down that allows for that maybe in 5 years, after a certain date, or maybe in 20 years, you're going to spend the entire fund that goes into the foundation and have it close its doors and be done with its funding. Or if you want it to continue on into perpetuity, then you want to have some governance set up for how going forward, maybe at some point the entire family may not be interested in running the foundation any longer. So you want to think about those things. You'll want to have conversations with your family about what happens when. And in those conversations, you're going to want to talk about being clear on your roles and expectations for family as far as participation. You'll want to set boundaries for the extent of your involvement or the family member's involvement. You might need to bring in an outside facilitator. And I'm sharing this from, I want to go ahead and give this information. The National Center for Family Philanthropy is just a wealth of knowledge on how to do a family foundation. And they have been tremendously helpful for us. They have a website that has just so much information that is free. They do have a program where you can be a friends of the Family Foundation and participate in some of their webinars. They have some great conferences and training sessions to help prepare families or to help guide them as they go through, as new generations come up into their family of giving. You'll want to plan for foundation effectiveness over family desires, because the money goes into, when you do a family foundation, the money goes into the public trust. You're going to want to gauge the family's comfort level and desire to be there, and then also you have to think about what kind of board of directors that you're going to have. So that's really important. Let me figure out where I am in my list here. So things that you'll need, basically when you have a family foundation, it's like running a small or large, depending on the size of the foundation, business. So you'll need to have something as simple but as important as directors and officers insurance and liability insurance. You'll need to establish if you'll have an office. If the office is going to be part of a family business, the foundation cannot pay the family business for rent. You'll need to have an experienced accountant and CPA for knowing how to file the 990 private foundation tax documents. You'll need to have someone who's going to take care of your bills, budget. You'll need to have a CPA that knows the rules. At first, we had our initial CPA firm that helped get us all set up told us that we just had to give out the 5% based on January 1 and what our how much our foundation was worth as of January 1. That's what we found out in 2020. By the end of 2020, we figured out that we should have averaged what our assets were that whole year, and we ended up behind in terms of our 5% giving. So, and this was the CPA firm that we had used had run our company books for forever. So we just assumed they knew what they were talking about, but it's just a really specialized area of the law to make sure that you understand how that will all work. You'll need to decide who will manage the money, whether or not you have, if you decide to keep it in the bank, typically it doesn't earn as much interest if you try to put it in a brokerage account and use investment managers. We actually have 2 different investment managers that help us manage our funds, and we did that because we weren't really sure which one to go with of the 2 that we were working with, so we thought we will put it in both funds. And what it does is it allows us to kind of have 2 different groups telling us, how to invest our funds, and it also is a little bit of a checks and balances. So sometimes they get a little nervous with each other, but it works really well for us because we know that they're going to keep our best interest in mind, and I think that that's really good. You can have family as staff, but there's some really strict rules about whether or not how they can be paid and for what they can be paid for. You'll need to decide if you'll have a social media presence, if you'll have a website, who will manage that, who will create it, if you'll have a Facebook page, Instagram, X, TikTok, Snapchat, and again, who's going to manage those. You'll need to make sure that you have a plan for you'll need to be sure that you're giving to qualified organizations. So with our family foundation, we can only give to 501c3s. So we have to do a little bit of research before we give money. We can't give to individuals. You can go through the IRS and figure out ways that you can give to individuals, but those rules are really strict, and we've been advised that that's probably not where we want to spend our time, trying to figure out who we can give money to directly. You'll need to have a decision about where the money goes, and do you need committees to help you decide how to get money out the door for distributions? If with your board of directors, will you have family only, and how many people will your board of directors have? You'll have rules for family participation. Do they need to be a particular age, or you're only going to allow them to serve on your board for 5 to 10 years? Different rules like that. Let's see. A couple of other family foundations in the area. I already talked a little bit about spin down, but that is definitely something that you really want to consider. There's a family foundation in Longmont right now, and they're in the process of having everything spent after 5 years of the founder's passing. And your founders, if you decide to start a family foundation while you're still alive, you can do that. Our founder did. He passed away in 2020, And then we had to figure out what his donor intent was, because we'd had some conversations, but we really needed to have some stronger and more in-depth conversations. It probably would have been a good idea if we would have had someone come in and sit down with us and say, you know, given what you're going to put into the foundation, you need to have a lot more structure in place. So that would have been really good. The other thing to think about with the longevity of your foundation, there's another small family foundation that I work with in the Denver area, and they are being run by someone who does not know the founders. And that was a discussion that I had with some of the family members for this family. How would you feel if we have this go into perpetuity, if you have no one else in the family wants to run the foundation any longer? And so basically, you're going to have people who are deciding where this money goes that you may or may not believe in their values, beliefs, and they may not continue on with the legacy that you would hope for. So those are important things to think about. And then at a conference that I was at with the National Center for Family Philanthropy, they say that first generation after the founders, there's a lot of sibling rivalry in that generation, and it can cause a whole lot of family discord. Any family members that you would like to maybe establish this as a way for them to make an income need to actually be doing work. We had an attorney that we used for a while that talked about a professional basketball player who apparently just paid his mom for being his mom, and they found out about that, and they got in a whole lot of trouble. There was a whole lot of penalty. According to the attorney, the foundation was shut down. I don't know if that's the case, but it's just something to keep in mind, that you can't just pay people for being a part of the family like with a paycheck. So it's complicated. We learned that you cannot sell foundation assets to family members. So for example, we had 2 properties come into the foundation immediately upon the passing of our founder. And we had some family members express interest later that they wish they could have bought those properties. Well, once it's in the foundation, you can't sell anything to family members. There's some really strict rules there. So that was disheartening for those family members. Another issue with the properties, one of them was a ranch, and the family wanted to turn that into a private family retreat that was also used for a nonprofit purpose to be a camp for children to come to in the summertime. As we did more research and had a discussion with the National Center for Family Philanthropy, they said, no, you can't use your camps for private family retreat opportunities. It has to simply be used for a camp. And so that was disheartening for the family, because they would have rather had that opportunity to be able to, even though the property was 140 acres plus that, there would have definitely been plenty of room to set aside just carve out a little piece where the family could use it, and it could still be used for the camp, but that just was not allowed under the laws. What just popped into my head is you can try to fly below the radar on that, and that's up to everybody individually. We chose not to. But family foundations, those are the kind of difficult parts, and the parts that we've had to learn over the last couple of years, as all of a sudden we had a really big change in our assets. But we have some fun. We get to award money in the community, so we give grants. We are up to, I want to say, 13 or 14 scholarships that we give in Colorado and Montana, so that's fun. We meet with those recipients after they've received them, and so it's really nice to see these young adults who are really excited about where they're going to go in life. We also have a birthday advisory fund for the direct descendants of our founder, and that is our way to get the family involved. So they're given an amount of money on their birthday, and then they designate where that money goes. They don't personally get it, but they get to designate that amount of cash about where it would go. And it doesn't necessarily have to fall within our mission. So if they wanted to go to the fire department or to the veterans or several other things, it can go outside of our guidelines for education. So just to wrap up, basically running having a private family foundation. It's like running a nonprofit business, so you're gonna really be running a business, so you need to have people that are prepared and ready to run that business. And you're running it in a sector that has a lot of challenges because there's been a lot of abuse, so there are a lot of rules where you're just like, really, why? Why is there this rule? And it's just because unfortunately over time, family foundations have tried to take advantage of the tax laws and do all sorts of crazy stuff. So I think that is it. So thank you.
So I'll follow on a little bit more onto these two presentations that I think are more technical, and talk a little bit about the heart part of this, giving. Because giving really is about where your heart is and where you want to see your money go when your day comes. And there are various different techniques. I was blessed with a grandfather that was giving and a dad that was giving, and probably the most important thing to my dad was that he wanted that to continue. So, and there were things that he's passionate about. He was a music person in particular, and so he did a lot for the arts here in town and other places. But one of the key things that my dad did was he talked about this stuff to us kids all the time. He set an example, and then he went and he met with each and every one of us and got over some of the humps that you've heard a little bit about today, because he told everybody what he wanted. And he told everybody how to deal with things, and he was an example to us, and he told us what he did to do that. How that goes forward, at least in our family, for a generation or two, because he's not going to be able to talk to my grandkids or my great-grandkids, right? But he's got to instill it into us. And so I really challenge you that whoever your executor is, whoever your kids are, that they understand what you want to do. It's something to talk about. I have a father-in-law that doesn't want to talk about it at all, even though I make him. So I kind of deal with on both ends of that spectrum. But I think it was really important that my dad talked to his kids about what he wanted to do. And then one of the tools he used was a charitable remainder trust, which allows the kids to ultimately get that money some years down the road, but allows the kids to give away something every year, similar to what Tony was talking about. And the trust has got to make a return every year, but somewhere down the road, 20 years or 30 years, however it's set up, that money still can go to the family, to those kids. In the meantime, they have to give that money away every year. And so they're engaged and they learn and they teach. So what did we do personally with our two kids? We sat down with them and said, okay, we have that money, but you know what? You get half of it, or you get a fourth of it, and you get a fourth of it, and we'll give away half of it. So our kids are engaged every year in giving, not their money yet, but hopefully someday they learn the process, right? Because you want to teach that on a generational basis. We want, and I think another thing that's important is, you want those kind of things to be a blessing and not a curse. So you don't want to saddle them forever and ever with a problem, but you want it to be a blessing so that they can get a blessing of it just like you can. To the point of how long, is that at 1 generation, 2 generation, 3 generation? I don't know, it depends on your kids. It depends on you. It depends on how well you get that process across to your kid. Not every kid's built for that. My brother has a much tougher time with all of those principles, I think, than I do. That's not right or wrong, it's just different. He's wired differently. But I think the basis that, the one thing that we could all agree on as siblings is that this is how Dad would have wanted it, and this is how Dad would have gone. So it's really a heart thing. There's a lot of technical things that we've talked about tonight, but it's really a heart thing. And I just encourage you to look at your heart, figure out then and what you want to do first, and then go sit down and talk to somebody and talk about what are all the different mechanisms that you can use to do that. And as they said, there are many, and each one's different. Each one's got pros and cons. You get with the right people and they understand those things and can explain them in layman's terms. It really is beneficial. And that's where, to some degree, Crossroads comes in that, education was an important thing, I think, to our family, I know to the Brawley family. And so Crossroads is kind of that. It's a crossroads of those things. And so there are various options of how you would set something up today, tomorrow, 20 years from now, that would benefit Crossroads. So hopefully, and I'm happy to answer any questions as well.
All right, so I mentioned that Sally Glass was a financial literacy teacher. She and her husband Simon also ran a number of businesses, were pretty successful. But then in 2022, they had a major catastrophic event in their family. Their son, Christian Glass, was killed in Clear Creek by the police. It was devastating. It ended up in court. A year later, last year, they ended up with a huge settlement, which they decided to give in his honor to charity. So she and her husband have spent the last year figuring that out. And that's the letter that she wanted to write to have me share was, she said, "We have in the past year spent quite a bit of time researching and planning our charitable giving, and one word springs to mind: overwhelm. We went through the following steps to help with this feeling and to keep things manageable. Number 1, mission statement. We felt overwhelmed by all the need in the world and how to decide who to give to. What helped as a family was to sit down with our children, write down our vision, and most importantly, a mission statement about what we wanted to achieve and what we were passionate about. Everyone will have a different mission depending on what speaks to them. Ours is to help and support young people on their journey in life, education, life skills, and mental health being core tenets." So, sorry, you're getting a lot of people that are interested in education because that's who I connect with. Number 2, choosing charities. Our next step was to find charities that supported our mission. There are great nonprofits and others that are not so good. We use Charity Navigator for larger charities, which assess the cost effectiveness and overall health of them. Overall, though, we prefer to support small, local grassroots charities as we find them more transparent and can see how donations impact those they aim to help. Number 3, how to fund. The simplest way is to write a personal check to your chosen charities, keep the receipts for your tax return, as when you donate cash to a qualified 501c3 public charity, you can generally deduct up to 60% of your adjusted gross income. We use a donor-advised fund to avoid the paperwork. We were advised that any fund of less than $30 million to use a donor-advised fund is so much simpler and more cost-effective to run than a foundation, as Tony has expressed. Many smaller foundations, we have found out, are closing and choosing donor-advised funds. We want as much of what we plan to give to go to those in need and not to pay for the expenses of running a foundation and having the time suck. So, and you've already kind of heard this, foundations require legal help, a board, accurate ongoing paperwork requirements, and must distribute 5% a year. Donor-advised funds, no administration is needed from the donor, no boards, no lawyer fees, distributions are very flexible as and when at will. In good years, you can donate more, and in poor return years, leave it to build up again. Schwab, Fidelity, and Vanguard all operate donor-advised funds. Do a search to find the best fit for you. Depending on the name you choose for your donor-advised funds, you can even give anonymously. So, and I will mention also that locally here, the Longmont Community Foundation has donor-advised funds. The Boulder Foundation has donor-advised funds. There are also some faith-based organizations like the Barnabas Foundation. So there's a lot of options if you decide you want to do a donor-advised fund. And I'll just mention in passing that Reggie's dad was on the founding committee, I believe, for the Longmont Community Foundation, helped get that started. It's kind of a neat little piece of history. Number 4, ongoing safeguarding peace of mind. Look after yourself and your family first. Give what you can comfortably afford and start slow. You can always increase contributions as you gain confidence and have a clear picture of your future needs. We gave conservatively the first year, but have increased contributions as our finances have allowed. We want our giving fund to be a legacy and run for future generations. Number 5, managing charities' expectations. Nonprofits need funds to survive, and they know it's easier to gain more contributions from existing donors than to attract new ones. Communicate clearly your preferences for giving. You may decide to give just once to fund an important project. You may decide to give once at the end of each tax year. You may decide to give once a month for a set amount. You may decide to give yearly at the annual fundraiser and also help run and support the event. Or, like Warren Buffett, you may donate the bulk of your asset at the end of your life in your will or your trust. You can request to be removed from all mailings and emails and direct texts if solicitations get overwhelming. Most charities are respectful. It's up to you to decide, and it's important to maintain boundaries so you can lead a peaceful life and stay supporting the charities you believe in. And a final note, we feel hugely privileged to be able to give to charity. We have all we need, and it feels good to be able to donate to those in need, not for glory or recognition, but to just give from the heart. There, but for the grace of God, go I, is what we always remember. So, some overview information about estate planning, and we've kind of gone in a direction of some of the giving, but I think for a lot of us, we want our estate to reflect our values. We want to support things that matter, to support our families first, but then also beyond that to be able to support other things and to figure out what those are. So some good starting information. We've got someone who's gonna pass around a microphone if you have questions that you want to ask, and you can direct it to a particular person or just let them take it generally.
I'm usually pretty loud. It's for you, estate attorney person. When you do a will and you have it signed and all this wonderful stuff, does it ever get filed with the county, or is it just randomly for the family to decide to turn it over or not? And it's a situation in my life I need an answer for.
Good question. And what I've heard from you just now and other people tonight, a term that I use to describe that, what's somebody going to do or how do people get along, I refer to that as family dynamics. So it sounds a little more positive than what you might be coming up with. Old style, it used to be when you signed a will, I'm talking a couple generations ago, you'd file it with the county. Now, honestly, if you signed your will today and I submitted it to the county, they wouldn't even accept it, or they'd look at me and say, what in the heck are you doing? We don't have room for this. So no, you don't. Sometimes law firms will keep the originals. My practice, and I think the majority out there, is we keep copies, but that the originals go to you. Copies of power of attorney documents are as effective as the original. When it comes to a will, ideally the original will, when a person passes, is submitted, or we refer to it as lodged, with the county, with the district court in the county in which you passed, or that you were residing when you passed. And at that point, it is. And again, I won't go into great details, but there are times that a copy is acceptable. So no, you need to, not to overuse the word trust, you need to involve people in your plan that you do trust. And I've had people before, like when we're talking estate, like power of attorney, that I'm not sure I would want that person to act as my agent now. I want to only when I'm incapacitated. And think about that. If you don't trust someone to act for you now, when you don't know what's going on, you would trust that person? No. So, again, this could go into a lot of different areas, but I think we all immediately think of family members. Depending on your age, chronologically where you are in your family, do you choose a parent, a sibling, a child to act for you? That may not be the best fit. It may be another individual. There are corporate fiduciaries. That's not always a great first choice, but there's sometimes that does make sense. So, does that answer? Okay, and there, that is just fine.
Okay, you have a piece of real estate, a house, nothing fabulous or anything, and you want to pass it down to one child. What's the best way so they don't, because I hear there's inheritance tax, then I hear sell it to them for $1, then I hear just give it, what's the best way so that they actually get your home and not wind up giving half of it in taxes to the government?
Good question. I thought what you were going to start to say was you might have 5 kids, but you want 1 kid to get something.
I only
and
have one.
Okay,
Simple.
and that I'll just throw out there because I think that's always a good thing to bring up is fair and equal are not necessarily the same things. And this is all about choice, so there is no right or wrong. Taxes. Colorado does not have what is referred to as an inheritance tax. So what you are giving is a gift. It's no different than if you wrap a sweater in a box and give it to your child for Christmas. He or she is not paying tax on it. Whether you give them a house, whether you give them $100 or $100 million, they will not pay income tax on that. There is no inheritance tax. No, I practice in Nebraska too. There is there. And as far as federal estate tax, that's kind of a moving target. Right now, any one person can pass with approximately $13 million, and the estate will not pay any tax. This isn't your question, but I'll throw it out there. There's no way really to avoid that, but there's ways with gifting and such that we can work around it and perhaps have somebody else benefit from it rather than paying tax. So if you are leaving a house, you could have it just go via your will, or a trust, that it just goes to the child. As long as the estate isn't worth today over $13 million, there's not going to be any tax. If some people say, well, I'll give it to them during life because, I don't know, you've told me there's no tax, but I still don't believe you. I'm afraid there's going to be some tax when I pass. Well, this is where we start getting very complicated. If 2 things. If you give something, because sometimes people ask this too for fear that how can I make sure that I would qualify for Medicaid, for example, if I needed someone to pay my care expenses, if I'm not able to, will they take my house? Well, that's a whole nother topic, but you can, eventually, if you've received public benefit, there's going to be a lien on your house when you pass, okay? Certainly, you could give it to your child today, and I have clients that have done that have said, I'm going to live there, but I'm giving it to my child so many years in advance so that I don't have to give up the house. But what we don't always keep in mind is what if something unexpected happened to that child? And what if that child got in an accident and somebody sued him? Or what if that child needed Medicaid? So you might just be shifting that. Another thing to keep in mind is if you give something during your lifetime, any kind of appreciated asset. So if your house, if you live in Colorado and you bought your house a year ago, the value has gone up this year, okay? So if you gave it, not necessarily with your residence, but if you think of like an investment property, if you were to sell that, just like if you sell appreciated stocks, you're going to have to pay a capital gains tax, okay? If you give an appreciated asset to someone like your child during your lifetime, they're going to have that same basis. It's just like they bought it for the same price you did. So if they ever need to sell it, they've got a built-in gain that they're going to have to deal with. Under current law, and the way it's been for a very long time, if instead you wait, you just enjoy the house while you're living, figure I'm going to give it to them through my will or my trust, they'll figure it out when I'm gone, then they will get a step up in that basis, meaning whatever the value of that house is at your date of passing, so if they get it appraised or market analysis, that's what they take it at. So if they turn around and sell it the next day, they won't have that gain. There are, just one more thing I'll throw out there, Colorado now does have what's referred to as a beneficiary deed, or what else do they call them, a transfer on death deed, so that the deed for your house, it's kind of like you would do with life insurance. You can put a beneficiary on it. During your lifetime, you can still sell it, do whatever you want with it. But if you've listed your child as the beneficiary on that deed, and it's a special form that you have to do, at your passing, effectively, they just have to show a death certificate to the county, and your name's removed, and they become the title owner. But tying it back to what I said earlier about wills and probate and all that, what I just described with the transfer on death deed is a non-probate asset. So say you did that today, and next week you do a will and you've decided, I actually want my sister to get the house, so I'll just put that in my will and it's fine. If you've already changed that deed, that will control. And that's probably one of the big points I'd make this evening is whomever you would work with to do some of your planning, just make sure that you're very clear how you may have had beneficiary designations, how you don't, what your will says. And then if you've had marital status changes, if you've been married, divorced, remarried, that makes a big difference. Not everything is automatically canceled. So I just gave you a very long answer. Did I answer your question? Okay.
I would add one thing to that is, I would just add that estate planning is a process. It's not something you're gonna do one time. It's something, as she mentioned, divorce, death, what are the 5 Ds? And those things go on all the time, right? And so it's a process. And, I'm personally long overdue at doing it because I have a grandkid since we did it. We've had, a divorce in the family since we did it. So you've got all of those things that constantly change. And so, it's a process. And, we kind of tag it at 5 years that it needs looked at, but sometimes it's less than that, so.
For the attorney. As a couple, is it better to do joint wills or individual wills?
Is it better to do joint wills or individual wills? Again, it's all about choice, but I would tell you, if I have done any joint wills, I may have done one in my entire career. I do not personally like joint wills. I think you can, if you're wanting to combine some of that, I think a trust is a better vehicle to do that, and I could explain that at another time. A will, anyone can change their own will, and when you say a joint will, I'm not sure if you're talking about the one will for both of you. There's also a term that's referred to as contract to will. And I have been involved with some very messy cases with that after that happens, where effectively you each do a will, you know that you can change it on your own because it's your own document. But then you decide you're going to sign this extra contract that says, I'm not going to change my will because we made sure that our wills are parallel and we can't change them. Well, then one of you passes and the other one's living a really long time and perhaps gets into a new relationship. And no, short answer, if you want full control over what you have and what you want to do with your assets, you want a separate document. If you want to do something jointly, there are ways to do that, but then you need to decide, and I'm talking in terms of the substance of it rather than the form, and come back to that in a second. But what you need to decide and be able to communicate to whomever is helping you plan is, do you want to be able to change your plan as a couple if one of you passes, likely one of you will pass before the other, do you want the survivor to be able to make changes? Or is your preference that once something happens to one of you, that you want a plan that's locked in place, that the bulk of the assets, who's going to end up with it and benefit, that you don't want that to be able to change? And that's what's important for you to be able to communicate to the planner. And then it's somebody like me that has to take that and put it into the appropriate forms. Yeah, okay.
I just wanted to follow up on what she was saying. Did I hear you correctly that if you gift the property before you pass away, that the person you give it to has to actually go all the way back to the original owner's basis? I mean, to that owner's, but if Uncle Eddie gave the tree farm to the family before he passed because he had dementia, he had things going on, so he gifted it, where's that basis value start?
It's
With
whatever,
what he paid for it?
Yep, it's whatever Uncle Eddie paid for it.
But Uncle Eddie got it from Vera May, his mom,
Then whatever,
his step-grandma.
then
And so what-
whatever he took it as. So if he got it as a gift, and it was a
He
gift-
inherited it, they were both on the deed.
Yeah.
It was
it
mom and
gets-
son, so she left it to son.
And you can have property, it gets fun. You can have property with multiple bases. And so if you sell something for $100, it could be if that person actually got it from 3 different people that had 3 different bases, that you could end up, yeah, you'd want an accountant involved when that sale happened. So,
Okay. Because the thinking is that since Uncle Eddie inherited it from her, then our basis is what Vera May got it for in the divorce with my grandma.
yeah, if
really
if there
complicated.
was lifetime gifting all along to the ultimate person,
Yeah, so it could even
is
go
whatever
before Vera May.
It's whatever that original person. But if there was ever someone received it, of course, if you purchase something, whatever you buy it at is
No,
your
this
basis.
has been passed
But
to
if
the
but if
family, to
it's
family, to
passed-
family, to family, to family.
If it's passed through the family and there was ever a death, was the reason someone inherited it, then at that death, there would have been a step up. But then if somebody
Oh, that
gifted
makes
it
sense.
during life.
Okay, so when Vera May passed away, then there was a step up to Uncle Eddie.
Yep,
So we're,
yeah, so you may be better.
oh, okay. But yes, I will ask a CPA. It's a different state.
And, I was gonna say one thing that Reggie said. I think it's very important that when you do planning, that you think about the next 3 to 5 years. Because, and if life happens between there, then you revisit it. But between your personal needs and tax law and all of that, things change. And you won't get your head around it if you think, well, 20 years from now. So, good point.
Stay right there. Go back. Okay, so my husband and I, we have a will, but it was made more than 25 years ago. So we have a special needs son, and we have 4 other kids, and it's a pretty complex family dynamic going on. And so, we don't have any experience on what to do, but we know we have a very difficult situation to work through. So where would we start? Going to an attorney, or do you have a recommendation? Where do we start just
Well,
talking about what to do?
I would be happy to talk with you about that situation outside of here, so someday you could give me a call. But to that point, if you have a special needs child and you have 4 other kids, for example, you might say, we want a certain amount to benefit the special child, and then the rest of it goes, these kids, they don't need it held in the trust, but we do need it held in the trust for this. How's that gonna work? In your mind, it may be very complicated. Mine, no, it's fine. We carve out that part, and you can have all these special provisions, and the rest of it, it could be very simple. So, no, it's very, very doable. And while I would be more than happy to talk with you. You can talk to whomever you want, but if you do talk to somebody and they say, oh, well, that's going to be really complicated, you don't want to do that, I would go to someone else, because it's very doable, but you want to make sure you have the absolute correct provisions to protect that child, but also whether or not they're receiving some benefit based on financial need, or they might in the future. What is in that document, it may only be a couple paragraphs, but how it's worded, it could keep that person qualified or could end up disqualifying them.
Thank you.
Okay, sure.
Oh, okay. I have two questions.
Sure.
So the step up that you're talking about, is that pretty much every state or just Colorado?
No, that's a federal.
That's a federal.
law, yes. And ideally, that will stay in place. I mean, it's always a chance. Prior to the last election, yeah, there were some, well, even a year or so ago, there were some very scary things as to what might happen. But no, that's the law as we know it, that there is a step up in basis at death on appreciated assets.
Okay, so a house in Texas in the 70s, when houses were about 20 to 25,000, is now
More.
so much more. So the step up would be at the death of the owner, and then if they were to sell.
Yes,
Now,
there.
if the inheritors.
And perhaps I should emphasize too, like in your example, or the example I made for you, even though you didn't ask this, that if you were to give an appreciated asset to someone today, just the act of giving them that, there is no capital gains consequence. I mean, if somebody, and I work with a fair number of farmers and ranchers, and so this becomes an issue, that if some, as we balance looking at taxes and, a whole variety of things, if they give farmland or the house, an appreciated asset, to a child today, and if either you or that child were to sell it, there would be a capital gains consequence. So if you bought something at $10 and it's worth $100, and if you keep it forever, doesn't matter. There's no capital gains. So if you gave that asset to your child and he or she didn't sell it, no big deal. But if somebody wants to sell it, then that's when it becomes the issue. And I will tell you, I've got a couple clients that are farmers that want to keep the farm in the family, and they purposely have given incredibly appreciated land to their kids, because they said if we don't want them to sell it, and if they're going to sell it, they're going to pay taxes. So we'll see. Yeah.
Okay, my second question is, okay, so you're pretty sure your dad left a will. Who the heck knows where it's at? This affidavit of heirship, is that the way to go, or would it be better to turn over everything and look for that will?
The second part of it, because what you're talking about with the affidavit of heirship, that is effectively saying someone died intestate, meaning without a will. If you die with a will, it's testate, okay? And the affidavit of heirship is saying, court, we need you to decide who should inherit it under the intestacy laws, because there was no will. And in the will, you could leave it to whomever you want. It doesn't have to go to the family heirs. But practically, what I would do, yes, turn over everything, and this is going to sound kind of funny, but I'm very serious. Look in the freezer, and if they have a counter microwave, look under the microwave, okay? Don't know why, but that happens so frequently as to where it is. But practically, the other thing is if you have an idea who may have been the attorney or whatever state this is in, like if you came to me and said, hey, this was in Colorado, with technology now, we all have listservs, all the attorneys talk to each other through emails, and not a week goes by that I don't see an email, hey, did somebody write a will for John Doe? If so, contact me offline. So that happens frequently, and on occasion, we'll find, like, I'll go, oh, yeah, I did a will for them. So that might be, but yeah, try whatever you can, or go back to the, if you knew the attorney, go back and see if they have the original or a copy.
Okay,
Okay?
thank you.
Sure.
Wanted to add a couple pieces of flavor to your questions on the house in Texas that you were talking about. That's the perfect thing, the perfect type of thing, an appreciating assets that has a low basis to give to charity, because the charity doesn't have to pay that basis. So if you're dividing that out and you have any thought of that, that's a great thing to give to charity. The other thing that I was going to follow up with you on the special needs child, we have that as well. And again, as I said kind of earlier, I think it's really important in those cases that you talk about that with your other kids. And that doesn't mean that the other kids like it or want to accept it or some of that, but I think it's really important that you talk to them about it, so that it's not a surprise and it's not all of that, so.
Going back to just giving a piece of property or something to one of your kids now, I thought there was a limit on how much you could give per year to a kid, so how do you do that?
Yes, we're getting a lot of tax questions here. What you're talking about is referred to as the annual exclusion. And with the start of this year, it's indexed for inflation. And any one person can give to any number of individuals $18,000 a year. So a married couple could give $36,000 to one person, okay? And if you have, to your example, you have 5 kids back there, you could give $18,000 to each one of them. You could give it to every one of us in this room. That flies above or below any radar. You don't have to report that at all. Then there is a gift tax that's out there, and gift tax is coupled with estate tax, so they're usually the same amount. So like this year, you could make $13 million worth of gifts and not have to pay tax. Anything above that annual exclusion, so that's $18,000. If you gave someone $100,000 this year, you only have to report $82,000. 100 minus the 18. You're supposed to fill out a gift tax return and send it into the government so that they can keep track of how much money you've gifted. Does everyone do that? No, you should. But what happens is then at your passing, we look back at how many lifetime gifts you made, because that 82,000 is subject to gift tax. But you didn't make $13 million worth of gifts, so you don't have to pay tax. If over time it reaches whatever in that year the gift tax limit is, you'd have to pay tax. But then at your death, whatever we can protect from estate tax, again, it's a pretty high number right now, the 13 million, we have to subtract the amount of lifetime gifts you make. So you don't get a double dip, if that makes sense. So, okay. And yeah, I guess on Reggie's point, good point about the appreciated assets. The other time that you can benefit organizations is if you have what's referred to as a qualified asset, anything that you have to take a required minimum distribution on, that if you take that out because you used pre-tax dollars to purchase it, and when you take it out, like an IRA, you have to pay income tax on it. Well, if, as part of your estate plan, if you want to give some organization, leave it to the school for their benefit, if you give them one of these qualified assets like your IRA, they don't pay tax on that either, okay? So, good point.
So we had a family death, 2 of them, within less than 30 days. And the will was set up in such a way, I guess, that since they died in such close succession, everything's going to probate now. even though it was set up to where it wouldn't go to probate. So is there a way to get around that? Like, if my husband and I were in an auto accident and we both died, then is there a way for us to avoid, set it up to where our kids wouldn't have to be stuck in probate?
Yeah, I'm thinking that's one of two things. Oftentimes in the documents, there'll be a survivorship clause, and if there isn't, state law, I think it is 30 days, that it's deemed, so if your will says, I leave it to these people, but if any of them die within 30 days of me, effectively, they're treated as predeceasing you. And so if you had it go to your son, but if your son predeceased, you wanted it to go to your grandkids. If the son died within 30 days of you, it doesn't go to like his estate, it would go to that contingent. But that doesn't explain the probate. What I'm thinking is, possibly, is how we were talking if people, was this a married couple? Yeah, I'm guessing what happened is they probably owned a lot of assets jointly, joint tenants with rights of survivorship. So when one of them passed, it would have automatically gone to the other. But then at that point, that person probably thought, oh, I'll retitle things and I'll avoid probate. But if they passed about the same time, they didn't. So they figure out which one of them died first. May not have mattered from a probate standpoint because whoever was deemed the survivor then owned all of these assets individually that they received as a joint tenant. And if, I'm getting some shaking heads, I was afraid I was gonna kind of glaze over the eyes. Yeah, it's definitely have that conversation because there are ways to avoid that. Okay. Mm-hmm.
Okay, thank you for coming and help me thank our panel here for their excellent input. I do want to just piggyback on something that Julie said about qualified charitable distributions. So if you have required minimum distributions from your IRA, this doesn't have to be something that you only set up for after you pass. This is something that can happen every year where you give whatever you want to give to charity through that instead of through cash, because with such a high personal deduction nowadays, you really can't itemize anyway. That way you still get the reduced income levels from not having to claim that distribution. And you can also still take your personal deductions. So that can be a tax advantage in your lifetime if you're taking those kinds of distributions. So just to know. All right, thank you so much for your time. I hope it was helpful, and have a great night.